Hi, everyone. We're going to get started really quickly. My name is Caitlin. I am one of the editors-in-chief of the Criminal Law Journal here at Berkeley Law. And so I just wanted to give brief intros of all of our panelists. So I guess we'll start from left to right. Professor Ellen S. Podger is the Gary R. Trombley Family White Collar Crime Research Professor at Stetson University College of Law. She has co-authored leading books on white-collar crime and authored over 70 articles. She has also received many prestigious awards, including the ABA's Rader Taslitz Award, and currently co-chairs the ABA Criminal Justice Task Force on prosecutorial independence. Second, we have the Deputy Director of the Three Strikes Project, Susan Champion. I'm laughing because I actually worked for Susan for a couple of years, so it's fun to see her. She does great work. She's been working on sentencing reform issues and played an integral role in the development and implementation of the Three Strikes Reform Act of 2012, otherwise known as Prop 36, as well as Proposition 47. Next is Hilary Blaut. She is the founder and executive director of For the People, a nonprofit focused on prosecutor-initiated resentencing. In 2018, she played a pivotal role in drafting and advocating for AB 2942, the first law allowing prosecutors to revisit and reduce past sentences. A former prosecutor, she champions second chances and has received multiple awards for her contributions to criminal justice reform. Next up is Judge John Gleason, a partner at Voice and Plimpton, LLP, since 2016. He previously served as U.S. District Court Judge and Assistant U.S. Attorney for the Eastern District of New York. He has also clerked for Judge Boyce Martin on the Sixth Circuit and holds a JD from UVA. And then last but certainly not least, we have Pamela Metzger, and she is the executive director of the Deason Criminal Justice Reform Center and professor of law at the SMU Dedman School of Law. An expert on the right to counsel and prosecutorial charging power, her work has been cited by leading authorities and by the United States Supreme Court. Please help me help me welcome them to the panel and thank them so much for coming today. So, round of applause.
Thank you so very much. It's really a pleasure to be here, and I'd like to thank the organizers for this wonderful day of talking about one of the most important topics out there, prosecutorial independence. And we saw in the last panel where we discussed prosecutorial independence, we talked about charging and discretion. We're going to move one step further now, and we're going to see that a lot of this is tied together. We're going to talk about sentencing now. So the first thing I want to ask each of the panelists to sort of set our stage, as they did in the last panel, is when we talk about prosecutorial independence and judicial discretion, for that matter, too, how does that relate to sentencing? What does that mean to you? Pam, why don't you start?
I had a feeling you were going to start there. I think of discretion in sentencing as being sort of necessary but not sufficient. And so what I mean here is discretion is not just the power to make decisions, it's the knowledge, the information to make high-quality decisions, and the time to make those decisions. And in the same way that we were talking earlier about charging and the volume of cases and the way in which, particularly again in lower level courts and misdemeanors, it becomes a little bit of a mill, too often in our system, sentencing is really, well, in theory it's discretionary in non-guidelines, non-mandatory minimum systems. It's actually, and I hate this term, but I'm going to use it here deliberately, it's become a form of case processing rather than the exercise of discretion. And I would say here that in particular I'm thinking about time served, which is not simply problematic in the ways that Kimberly Furzan has recently talked about it, but I'm going to argue that every time served sentence is a failure of discretion. It means that that discretion could have been and should have been exercised earlier, at least in non-guideline systems.
Judge, moving to judicial discretion.
Yes. Okay. That's enough for me, actually, Ellen, to start. I'm the oldest one here by a long shot, so I remember the days, and we all bring our baggage to the table. I was a federal prosecutor for 10 years, federal judge for 22, and now I've been on the defense side for almost a decade. And so I bring that baggage to the table. But I remember the days when it came to sentencing, all the discretion was in the hands of the judges. Prosecutorial discretion was not an unimportant topic. It was critical, but it was part of a matrix of exercises of discretion. Policing was important. And then once it got into the prosecutor's office, charging discretion was critical, as the last panel made clear. Plea bargaining discretion, also within the prosecutor's office, fundamentally important. But now, and ever since the switch from the indeterminate federal regime to the Sentencing Reform Act and mandatory minimums, now prosecutors exercise sentencing discretion. It's not, when I was a young prosecutor in 1985, I was told, we have no role at sentencing except to correct factual misstatements made by defense lawyers like Pam, who was a defense lawyer. She was a baby defense lawyer in the same district. But now prosecutors also sentence. Just a couple of examples. Receipt of child pornography carries a mandatory minimum of 5 years. Possession has no mandatory minimum. Unless you're creating it, you can't possess it without having received it. So prosecutors decide whether to charge a mandatory minimum 5 years. Some prosecutors have, in the District of New Jersey, when Paul Fishman was U.S. Attorney, they actually called it a sentencing panel within the office that would make a sentencing decision. Sometimes, with respect to mandatory sentences that I hope before we're done we talk a little bit more about, prosecutors have the discretion to remove the judging role entirely from the case. To invoke a mandatory consecutive sentence that might produce a mandatory life without parole. So the feature, it's not a new landscape anymore, but the feature of the landscape over the last few decades in the federal law has been prosecutors share the sentencing discretion with judges. It's an overreaction to a system in which judges had unbounded and unguided and unexpressed the discretion, the reasons for their exercises of discretion were unexpressed, essentially unreviewed. It allowed implicit and explicit biases to affect sentencing outcomes. And even the most harsh critic of the reform movement, and I count myself among them, agrees we needed something to remedy that wasteland in the law, but we just went too far. Hopefully more about that, but let me yield to my colleagues on the panel for the moment.
Thanks. So the question about discretion and prosecutors, and I think I'll sort of pick up kind of chronologically where you left off and turning to discretion at the point post-conviction, right? This is where our work sits, that prosecutors need to have the discretion to be able to look back at their sentences. So they have discretion at the time of asking for certain sentences and seeking excessive sentences and asking for enhancements. And where our work comes in is basically advocating that prosecutors should be able to also come back to court and say, I sought this sentence, or this sentence was sought under my administration 10, 15, 20 years ago, and now I want to use my discretion to evaluate how this person has been doing. Is this sentence inconsistent with current day practices? Should this person still be incarcerated? Is there really a public safety issue at hand? or could this person be better served being in our community? So for us and our work, discretion, on the back end is the pathway to freedom for many people who are in prison right now that do not need to be there. So obviously, we are big proponents of discretion. We think that prosecutors should be able to exercise it at all intersection points throughout the process. And especially, we want to see more of this happening on the back end. California was the first state to pass a law that gave prosecutors this discretion to go back and undo sentences and bring people home. There's other states that have passed these laws, but we really want to see all 2,300 prosecutors across this country embracing this discretion and using this discretion and weighing these big complicated questions about who needs to be in prison and who needs to be home.
And the work that I do at the Three Strikes Project is all in the post-conviction space, and I've worked in, I'd say probably 60% of the counties in California state. And as many of you probably know, California moved from indeterminate sentencing to determinate sentencing as an effort to make the process more fair, less biased, less susceptible to things like racism and socioeconomic bias, et cetera. And what they found was that it still worms its way right through the system. The system is still shot through with those inequities. What I've found in the work that I do is that judicial discretion is sort of, as Hillary said, where everything sits. And in some places, you could even do county by county, the judge seems to be sort of in lockstep with whatever the prosecution is doing, right? And often relies on the prosecution for its signal about how to rule in a particular case. And then in other counties, for example, LA County, which is huge, each judge kind of has their own little fiefdom, as it were, and their own ideas. And I have found that that has often been the most useful place or the worst place to try to get some post-conviction relief from a judge who is seeking to use their discretion in a way that is just, in a way that is fair, in a way that recognizes the inequities that are built into the system. I think most of the judges that I encounter recognize that California has a history of overly long and harsh sentences, but they're also beholden to the voters, right? Because the judges are elected, and they don't want to have their names on the front page of the newspaper, as some have, or letting someone out who then goes out to do something that is very dangerous. So I feel for judges, I honestly do, and it's certainly always easier to go the path of more security, more safety by keeping somebody in. However, I think many judges regret some of those decisions and really look at things like public safety and things like justice in a different way, in a more progressive way, and in a way that allows them to use that discretion for our clients who have been serving very long sentences for very minor crimes.
You all have brought out some of the challenges that we face with sentencing, and some of those challenges are focused on the judge, some of those challenges are focused on the prosecutor, and some of those challenges are also focused on the public and the public reaction to it. What are your thoughts about some of these challenges that are being faced currently, and what can we do about it?
So I'm going to just start by just clarifying for some of the students in the room that we do have this two-tiered sentencing system, right? There are places like federal court, which is where I started my career, where sentencing means that a full-time professional comes and sits down with the defendant and does a detailed interview, interviews the defendant's family members, speaks to, if there are victims in the crime, speaks to the investigating agents, speaks to the prosecutors, writes, and I think it's fair to say, exhaustive report. The report itself is litigated because it's a guideline system, meaning there are determinate sentence ranges. And it is only then that a person is sentenced. There's an enormous amount of information. There are other systems, primarily state court systems and the lower level court systems, right? The lower level of the offense, the less information there is, where sentencing is a collateral consequence of a plea. That's it. You plea, and your sentence is negotiated as part of the plea bargain. The judge never knows anything about the defendant. The judge knows nothing about these concerns about what is just, what is public safety. So to be clear, we're spanning a really big range here. So when you talk about public perception and the role the public plays, part of the challenge here is in systems where the actors themselves know almost nothing about the individual circumstances of the human beings that they are putting in cages. It's very difficult to communicate to the public what sentencing means, what its significance is, and because we have become so cavalier about what punishment is, we're not doing a great job of conveying that to the public. And so I'll give just two quick examples. 1 in 3 people in the state of Georgia is on some form of court supervision. Sit with that for a second. 1 in 3 people has to answer to somebody else about, I think that's still current, isn't it, Sherry? Yeah. Where they go, whether they can cross a county line, whose house they can be in. Their basic freedoms are constrained. That's one kind of punishment. And then we have the other kind of punishment that we sell as entertainment, whether it's dramatic entertainment in something like Oz, or it's one of these cop shows, what makes it really sexy, or even this very interesting new show that's out right now. I think it's on Netflix. That's the Arkansas, Unlocked, the Arkansas prison inside. But we consume punishment as a form of entertainment. And I think that's largely a function of our failure to humanize the people who are in the process.
Should we keep going like this?
Sounds great.
I was going to make this point differently, but I can make it as an adjunct to what Pam just mentioned. And in terms of like orienting it to the question, it's important, I think, to educate the public about the difference between what might feel good, like there's a prominent crime, so you increase sentences, and what actually works in terms of crime control. So, I sit on the Sentencing Commission, and I speak for myself, not for the commission, but for decades, people who committed an offense while under supervision, so 1 in 3 of the people in Georgia, would have an uptick in their criminal history score, 2 points, because of that fact. But when you mine the data, and there's some good and bad things to be said about the history of the commission on which I sit. I criticized pretty much everything it did for about 25 years, and then President Biden put me on it. But one good thing to be said about it is it gathers data, and it turned out the data show that there was no greater recidivism risk associated with folks who were under supervision when they committed the crime. So we wiped out the status points. So data are very important, and we've by going back to the writ large, when you have a system in which you accorded so much discretion to judges, and then you take it away, you don't take it away completely. Nobody's in favor of just prescribing, specific sentences for specified crimes. We want discretion, and it's like water; it seeks its level. When you take it away, and in a way that was entirely unintended by the founders of federal sentencing reform, taking the discretion away from judges relatively empowered prosecutors who had these mandatory sentences that they could use to suit their own purposes, to induce people to plead guilty, to induce them to cooperate. And so when discretion is placed in the hands of prosecutors, and I don't mean to be on a high horse here, I was chief of the criminal division in Brooklyn, and I use these tools the way prosecutors use them. But that's why we ended up with a 700% spike in the federal prison population. So when you put the discretion in the hands of one of 2 litigants in the courtroom, you're going to have consequences. Those were the consequences. And now here's my real point, and then I'm going to stop. We've gotten to the point where, as just a political reality, even when we know we've gone overboard, we can change criminal policy and sentencing policy on a dime when there's a prominent crime, a carjacking. But once we've realized we made a mistake, and this is going back to all the students weren't even yet born, we still have this whole Willie Horton thing from the 80s where it doesn't get you any votes to change policy in a way that inures to the benefit of a criminal defendant. So even though the First Step Act in 2018 was a bipartisan recognition we'd gone overboard, we've over-incarcerated, we need to decarcerate. Even when there's a consensus that we've gone too far, change in policy in the other direction is like turning the Queen Mary around. It's very hard. And it still feels good. There's fentanyl overdoses. It feels good to increase sentences, but the data show that when you already have sentences that are of undue length, of excessive length, and then you increase them, you actually undermine the crime control goals that the system is supposed to vindicate. You increase recidivism rates when you increase that sentence from 5 to 8 years. And the public doesn't understand that at all. And that educative problem is just humongous, but it's there. But I think the solution is that, you can only go for so long having 5% of the world's population, 25% of its prisoners. That's gone down, but only a little bit. And all it will take is an uptick in the murder rate, somewhere, and whatever thawing of the problem that we had for so many years can be stopped way too quickly.
I would add to that, Judge, it's very apparent the reactive nature of our legislature in that regard, and how so many laws and the whole overcriminalization movement that became so active probably about 10, 15 years ago. This is sort of an extension of that overcriminalization movement to some extent, is because we're seeing that the overcriminalization that increased the number of laws, increased the sentences, was not effective. And now to go back and try to educate people on that and also maintain consistency in the system becomes difficult.
Difficult, but not impossible. I think that, I don't know, I agree with all of that. I was a prosecutor, and I feel like I have experiences of doing the job and doing my best to try to balance these equities of justice and accountability, and certainly got some things wrong along the way, but I fundamentally believe that we can turn things around. I fundamentally believe that there is a lot of progress being made across this country. I'm inspired every minute of every day by somebody that I see somewhere across the country creating some change and pushing on the systems that we have and what got us here, and trying to dismantle those aspects of it. I think in terms of public perception, I think that the notion of what public safety means, I think, is a real problem. And I think it's the notion that if you have a bad actor or somebody who commits a bad act, right, even taking away that the person on their worst day did something, that if you remove them from our community, that, one by one, by removing people from our community, that's the way that we're going to be able to become safe. That's how we're going to have these healthy communities. And I think we really get that wrong. I think we really got that wrong. And I think that, we have a real opportunity. You talk a lot about, kind of where we are right now in terms of how many people are incarcerated and how many people are shuffled through into the carceral system. For me, when I was a prosecutor, I really had this belief that when I was a prosecutor in California, California Department of Corrections and Rehabilitation, the R was added on to that title. And even when I was a prosecutor, people would still call it CDC and have to be corrected and say, oh, don't forget the R. But this idea that, we have filled our prisons with a lot of human beings who have a lot of potential to be in our communities. And I think that the general public, when they understand the kinds of people that we're talking about, the people who are in prison that are writing letters with their children back and forth and, really trying to keep these family ties together even through separation, and the jobs that they are completing while they're incarcerated, and the workforce potential that's being created behind bars, the rehabilitation that's happening behind bars, that when the general public understands who these people are and then can learn about what they're doing when they're home and the contributions that they're making, I think that that is where we need to push so that people understand that that's really the definition of public safety, when you are reuniting families and you're bringing people home so that they can build back the fabric of their communities. We all know what Tough on Crime did, right? We all know that that disseminated in a lot of ways Black and brown communities, and it just fragmented all of these families. And that is part of why we see what we see today. But if we can rebuild the fabric of these communities, and there are hundreds of thousands of people behind bars just waiting to come home and work full-time jobs and walk their kids to school. So, we really try to push on that. And everybody that we talk to, when we explain, well, who are you talking about when you talk about resentencing people? We say, oh, well, let me introduce you to, Philip. Let me tell you about what happened to him and what led him to commit the crime in the first place. And they're like, oh, I didn't realize that. And let me tell you about what he's been doing since he's been inside, right? Let me tell you about the correctional officers that even say he should be out, right? We've worked on a lot of these cases together. And let's talk about who he is today. You want to know what he does all day? He wakes up at 6, he goes to bed at 9, he goes to church on the weekends, he volunteers at schools, he does mentorship to interrupt future cycles of violence. So, like I said, when I was a prosecutor, I really believed that after I prosecuted a case and it was over, there was this whole other system that would sort of figure out when people are ready to come home, right? There's an R, they're rehabilitated, there's a whole system that functions, and then when people are rehabilitated and ready to come home and can come home, they could just leave prison, right? Which is super naive, and it's on me that I didn't ask and provoke some of those questions. But what we know now is that it is very difficult to get out of prison, right? It is very, very difficult to get out of prison. You have to have a governor that wants to use their pardon pen. You have to have an effective parole board, right? And in most of the country, that does not exist. Or you have to have second look laws that are also very difficult to pass. We're fortunate here in California where we have had some success in getting these laws passed. But without these, you have a big, massive funnel that just sort of is pulling people into the justice system, and then you have a very, very narrow way of getting out. But when we work on the back end and we work on these second look laws, and we can get these people out and we can continue to put these stories out into the world and tell people who we're talking about, I really think that's going to shift the way people think about safety. It's going to shift the way people think about reform, and it's going to turn everybody into an advocate to bring these people home and get them back with their families and their communities.
And I love that message of hope.
Right.
I will
Stay
say-
with it. Stay with that.
I know. I got in a big Facebook fight. I'm an old with someone about an initiative that is currently on the ballot in California that is meant to sort of roll back some of the reform, the good work that's been done in reform recently in the state. But as far as, and that brings me to public perception, right? So I'm at the Three Strikes Project. We started because of California's Three Strikes Law. The Three Strikes Law was the success of that law was almost a direct result of public policy, because a young woman named Polly Klaas was viciously, brutally kidnapped and murdered. And a law that had been going nowhere suddenly became incredibly popular, and everybody wanted it, and suddenly, there we did. We had the Three Strikes Law. A lot of my clients, 10 years later, told me that their parents had voted for that Three Strikes Law because they said, well, that wasn't supposed to be for my kid. My kid just has a drug problem and steals stuff. Why is my kid getting life in prison, right? There's another really high-profile case, the Brock Turner case, where a judge used his discretion to give this young man a sentence that showed some mercy. And frankly, for many people of lesser means, this would have been a sentence that a lot of people would have really respected and thought, okay, good, we're doing this. There was so much public backlash against that sentence that they did a whole recall and the judge lost his job. And I would be in court, for example, in LA, talking to a judge who was like, this guy's gonna lose his entire pension if he gets recalled. This is gonna be a real problem, right? So there's a lot of public pressure on judges based on people's perceptions about how our system works. The issue is that nobody, except for the people that are doing this work, know how this system works, right? The parents of my clients didn't know how this system works. You know, they get a ballot initiative, which only complicates matters, right? They're suddenly supposed to become experts, subject matter experts in something, and vote on it and cast an informed and intelligent vote, right? That's not very, very possible. And in the Brock-Turner case, we can all, you know, have different opinions about how that should have shaken out. But again, it's an example of a judge who made a decision and who then paid the price for that decision because of public perception. So I don't think there's any way that you can divorce judicial discretion from public perception. That said, I think Hillary's point is really well taken. The more we can educate our communities about how our system works, the more likely it is that people will be able to understand that efforts to prevent these kinds of things from happening, that the data show that certain sentences stop working at a certain point in time. There's data that says after a certain number of years, imprisonment no longer has any merit in terms of rehabilitation, and in fact only makes that person more likely to recidivate if they're released, because they lose their family connections, because they lose their ability to be employed. All of these other things come into play. So if we continually educate our communities about how the system actually works and how we can use other means to prevent recidivism and to prevent crime, we can actually make some progress.
Ellen, can I just follow up 1 second? I want to refine, because I'm so much closer to Hillary than she thinks. The second look statute in the federal system is the compassionate release statute. There are other mechanisms to reduce sentences, but the principal one these days is that. And I'm all for using those as mechanisms to ameliorate the effects of over-incarceration. What I mean by the humongous effort to educate is the following. It's just for example, without taking a position on the merits of such a piece of hypothetical legislation, if a member of Congress now said, geez, we got a bunch of fentanyl, a spike in fentanyl overdoses, let's do a mandatory minimum for fentanyl. I think in an educated world, another member of Congress would be able to get up and say, well, why don't we just look and see whether that will do anything to decrease the supply of fentanyl or decrease the demand for it. Let's see whether or not doing that is going to raise recidivism rates as opposed to perform some laudable law enforcement goal. But the information gap now is none of that stuff is on the radar screen, and what happens is just asking those questions becomes an insuperable barrier to getting reelected for those folks. That's my colleague at NYU, Rachel Barkow, wrote this book, Prisoners of Politics, where she lays out all the social science about mechanisms that did nothing but create a one-way ratchet that increased sentences for 25 years, actually undermined the law enforcement purposes that those who advocated for them relied on. They actually didn't reduce crime, they increased crime. They ruined families, they ruined communities. And that is what the whole Willie Horton phenomenon has kept the American public from being exposed to, is the kind of logical, data-based approach to policy change.
Well, can I just piggyback on that, though, and say there's another piece, though, which is that so much of our system is subject to electoral politics. So I sit in this particular political moment with really mixed feelings about what life tenure means, particularly on certain courts. But in most of the world and that we live in sentencing, right, prosecutors are elected by and large, right, and most of the time, in most places, in unopposed elections. I'm not talking about in big urban areas, which is where we tend to concentrate our narrative. But in most prosecutor elections, you might as well be appointed, right? because there is no opposition. I don't know what the most recent number is, but it's well over 80% in a lot of places, a lot of states for local prosecutors. And local judges face the same challenges. So I was just telling Judge Gleason, one of my fondest memories from when I was a young federal public defender was being in court with a judge named Sterling Johnson, who had been a state court cop and a drug czar, and he was sentencing a drug courier who'd come in from another country, and the guy had to have been 100 years old. I don't know. I was 12 at the time, so he looked old to me. And he was in a wheelchair, and he had a colostomy bag. And I was in a federal circuit that was really liberated from a lot of the constraints. We were in the Eastern District of New York, where it sort of didn't matter what the Thornburg memo or anything else said. The office focused on justice. We had very, very, very reasonable approaches to what was a very unreasonable sentencing system. But the guy was still looking at a mandatory 5 years. And Judge Johnson, who understood the power of life tenure, looked over at me and he looked over at the prosecutor and he said, "Time served." And the prosecutor started to sputter, and the judge said to the marshals, "Make sure he gets over to ICE before anything else can happen. I'm pretty sure there's a deportation or an exclusion order standing." And he said to the prosecutor, said, you want to appeal? Go ahead. He'll be gone before you're done. That's what life tenure means. That's what prosecutorial, right, power in relation to unlimited judicial independence means, right? Was he going to get impeached over that? He was not. Go the other extreme to Brock Turner, right? And you see a judge being recalled for an exercise of discretion. And I think one of the things that we have to reckon with in this conversation about whether it's charging or whether it's sentencing is that we are toggling between a democratic impulse to elect prosecutors and elect judges who reflect community values. And again, if it's not a presidential year, you can ask whose community values, because about 10% of the people vote in a non-presidential year. So you're not really talking about the community. You're talking about the community that hasn't been arrested, convicted, incarcerated, and then that bothers to show up. But that's one model. And the other model, right, is appointment in this very rigid system where we're stuck with it. And let's be clear, discretion runs both ways. So I've been in the Sublime, which was the Eastern District of New York, and I spent a lot of my career practicing in the state courts of Louisiana, and let me tell you, that's more like the ridiculous. Except it's not. It's hundreds and thousands of people going to jail, right? And those are many, many places where I wish discretion was constrained, where I don't want as much independence, or at least I want more legislative control over what prosecutors are able to do. And so I don't know that there's a one-size-fits-all solution for this, except to say that, again, everything you've heard here that's made people nod are the stories about human beings. And the bigger the system is, and the greater the volume, the less likely it is that a judge knows anything about the defendant, that the prosecutor knows anything about the defendant, or that the defense lawyer knows anything about the defendant. And once that happens in our sentencing system, you can call it discretion. It's not, it's processing.
One of the things at the American Law Institute that was heavily discussed was second laws, and whether or not that might be a remedy to sort of look at sentencing and discretion of sentencing by having the opportunity not only to sentence at the front end, but sentence maybe in the middle and maybe at the back end. And I'm wondering, what are your thoughts on that as something that might offer some discretion that might ameliorate some of the issues that we're seeing here?
We start that.
So that's a really good question. And I just share that discretion goes both ways concern and think a lot about our adversarial system and whether or not the courts can be sort of an arbiter between the two sides, or is there a way to not have it be two sides? I think about that a lot. What I like about second look sentencing is that it removes us from the incredible pain sometimes and drama of the initial sentencing, right? Where the victims are very, very affected and very, very close to what's happened, where the prosecutors are really trying to win, where the defense is like pulling out all the stops to do whatever they can, right? It takes us away from that high stakes moment. It lets the passage of time sort of happen. It allows not only for the emotions of that trial to sort of dissipate, but also gives the offender an opportunity to look at what has happened and to process what has happened and to think about ways in which they can, look for other avenues, right, to grow, for lack of a better word. So that, I think, is one of the most appealing things about Second Look. It also, I think, again, removes us from some of the zeitgeist of the time, right? The pendulum swinging of highly conservative to highly progressive, right? It gives us a little bit of time between there as well. So in those ways, I think that Second Look is wonderful. It does still, however, leave someone holding the bag, right? Ultimately, someone is going to be making that decision, and somebody's going to have to be held to account for whatever happens after that decision is made. But I think that, again, that time passage just makes all the difference in the world, and they can be very effective ways to correct over sentencing.
Right. Yeah, and I think, one of the interesting pieces about Second Look, when you're looking like beyond conviction integrity or issues where there's wrongful conviction or misuse of evidence, so forth, is that, in this lane, it's not really about, who did something wrong or pointing fingers or having to relitigate an entire case. There's an opportunity for looking back at a case that can be, it is meticulous and time consuming. I don't want to say it's easy to process cases on the back end, but it does offer an opportunity to not have to necessarily fall on one sword, right? So in the work that we do, when we talk to prosecutors, it's not about you did something wrong or you're bad or any of these things. It really is that we've had an opportunity now to learn, right? 10, 15, 20 years have passed. We know a lot more now about adolescent brain development. We know a lot more now about the impact of some of the programming that's happening in our prisons. Not enough, certainly, but in some places there's a pretty good investment that's happened in programming in prison. And so we can look back and we can see sort of with new eyes, with fresh eyes, how trauma plays a role in people's actions and how certain programming can address substance abuse and trauma and sort of ameliorate issues around whether this person's going to reoffend. We have, I think it's 60% of people in prison are over the age of 55. So we've got people in our community people in prison that could be in our community. The old adage that prosecutors say, people will age out. I don't love that term, but when we talk to prosecutors, they're like, oh yeah, people age out. So there's just a more of an awareness that for all of these things that are happening, both programming, what we know about science, what we know about the adolescent brain, what we know about people who, quote, age out, people that have been in prison already for a decade, right? And it's sort of common sense that, nobody in this room is who they were 10 years ago, and the same is true for people who are in prison. So I think it is one of the best opportunities to be able to address some of the things that the panelists have been talking about, especially if you have the view that discretion is really just more processing and some of those outcomes will be disparate. This is an opportunity to be able to address some of those disparities, right? I mean, and the biggest one that you have an opportunity to address is racial justice, right? So the majority of people who are in prison are Black and brown. When you do resentencing work, the majority of people that you will have an opportunity to support and help and get home will be Black and brown people. So it serves for a lot of those opportunities. And the other thing I would say is that we have instances so often that we're talking to people who are in prison who will tell us what it feels like to be in prison, and they will have a cellmate or somebody that they're talking to on the yard, and they will share, this is what I did, and these are my priors, and they'll talk to one another, and they'll say, well, I'm serving a life sentence, and I'm literally, this is the same exact crime, and you're getting out in 2 years. So, all across the prisons, there's this sort of parity feeling that's going on in the prisons where people are serving sentences that are totally, completely different from one another, even though the facts are very similar. And so this notion also gives an opportunity to the prosecutor and to judges to say, okay, I'm looking at this case, 15 years have passed, I can go and ask somebody right now to look at this case and what would they give this person if they were sentenced today? And if the answer is they would get 4 years, or if the answer is they'd be out right now, it's an opportunity for the prosecutor then to rectify that and provide relief. So there are ways in the resentencing and in the second look realm that you can really begin to address or attack some of these injustices that are happening on the front end. And from everything that we've learned and what we know now about the outcomes that we don't want to see on the back end is an opportunity for us to really get at some of those injustices.
Oh, God, there's so much to talk about. Honest to goodness, I have about 4 hours of things to say to elaborate on what Hillary just said. I'm going to try to condense it. Nowhere is the need for a second look more important than in the federal system, because the change in regimes was intended to create uniformity, create certainty in sentencing by eliminating parole, right? The parole system was wiped out in the federal system. You only get 15% of your time off for good behavior. An enormous change, and at the same time, murder rate was 7 times what it was today. So there were all these onerous, the drug offense mandatory minimums, the firearm crimes I'm going to get to in a minute, mandatory consecutive crimes for multiple 924C violations, use a gun in connection with a robbery or a drug trafficking crime. And there was no replacement for what was thought to be an opaque parole board, which was actually deciding the actual length of sentences. So guys went in. I have a pro bono project now where my clients were subjected to the single most onerous, talk about prosecutorial discretion. Someone robs 4 bodegas and they have a gun. A prosecutor can charge the 4 robberies and then seek an uptick in the sentence on the possession of a gun. Or they can choose a separate offense, 924C, firearm crime, and have the first such conviction be 7 years, and then the second 25, and third 25, and 25, all mandatory consecutive. And the Sentencing Commission, which, again, never did a whole lot of favors, in my view, for years for defendants, reported 3 times in 14 years that prosecutors were invoking the harsh route, the die in prison route, instead of an uptick of a few years, disproportionately against black men for decades. And they were only invoking it when the black men insisted on their trial, so you could plead away the successive 924Cs. My typical client committed 4 bodega robberies at age 19 and didn't plead guilty and would die in prison, but for a second look, whereas the co-defendants who pled guilty hit the street decades ago. And anybody who believes that someone who commits multiple crimes with guns can't receive a grossly excessive sentence hasn't been hanging around federal court the last 30 years. And anybody who believes that someone who fits that description can't grow up in prison to be not just a reformed person, but an admirable person, has no idea what people are capable of. But the degree to which, my wife was a white-collar lawyer for 20 years, now is back to her first love, psychology. She's studying law and psychology, bringing to bear the psychological perspective that insufficiently informs justice policy into the law. So recently, we have so much to talk about.
So much.
The Sentencing Commission this last year brought in neuroscientists and psychologists to testify about cognitive development of people into their mid-20s, legally adults, not cognitively. As of November 1, there's now a downward departure in the federal system for folks who either committed their offense of conviction before their mid-20s or have criminal history points attributable to juvenile offenses. To get back to the I would love her to study the psychology of prosecutors who cling to sentences, even though nobody can defend their excessive length, as though they were the only sentence they ever got in their whole lives, right? The inability, it's the same with wrongful convictions. You're at a progressive state. The degree to which prosecutors will cling to a wrongful conviction that was obtained on facts on which they would never even dream of bringing the case today, or cling to an excessive sentence they don't even pretend to defend in the interest of finality, you can't overstate that. So second looks are unbelievably important. They're available now in a very narrow window in the federal system for extraordinary and compelling reasons. For decades, the BOP was established as the gatekeeper. They never brought the motions, so in 2018, Congress changed the law to allow inmates to bring them. We have a project at my firm. I have 70 lawyers. There's some good things to be said about big law. Not as many as I used to think, but one is there's a lot of people there, 70 lawyers, and we've gotten 61 sentence reductions for these 924C stacking cases. Average sentence reduction, 39 and a half years. Wow. So, we're sending people home to families that love them, communities that need them, but it's too narrow a window. It's there. It's very important. For years, the ALI and other very smart people proposed ways in which to get back in front of the sentencing judge on a second look. Again, I'm speaking for myself individually, not on behalf of anybody else in the commission. But we need ways in which there's a bipartisan consensus. We over-incarcerated. We need to decarcerate. One way to achieve that is to have more sensible upfront sentencing policy. Another is to be able to have a wider avenue of relief for people who got those excessive sentences. Right now, it's not wide enough, in my personal view, but at least it's there, and it hasn't been there since 2018.
So I'm going to push back a teeny bit. I think second look is great. I think second look works for people who've been in long enough for us to talk about a second look. And that is not the vast majority of the people who are packing our jails. It's certainly not the majority of people that are packing our prisons. And for students, the difference is jail is typically where you're either waiting for something to happen or someplace for people who've been sentenced, usually to misdemeanors, right? What I'm going to say is that I believe in second look. I wish that anyone, including the BOP, would think seriously about compassionate release. Those things are all incredibly important. I worry about the diffusion of responsibility. I think and maybe you can speak to this, Judge, is that there's something very important, I think, about having to look at somebody and make a sentencing decision. As a practicing lawyer, there was a possibility a judge could try and defer everything down to the magistrate except for sentencing. And as a lawyer, our rule was always you never do that because you want the judge to make sure the judge sees your client as a person. But this was federal court. These were high-quality judges. You had papers, things that were read. Most people in this country are not sentenced that way, and most people in this country don't get long enough sentences to get a second look. And for most people in this country who get sentenced, I don't care whether it's a week or it's a year or it's 2 years or it's 3 years, okay? Their lives are ruined. Sometimes maybe it's where they needed to be, but often it is a function of that case processing. So I worry a lot in places where there are high volume, whether second look lets people off the hook, whether it allows prosecutors and judges to say, I'm going to do what I have to do now, somebody else can clean it up later.
You really need it all. I mean, we're just talking about different facets of the system. They include, it's not difficult to figure out. Prison population is a function of how many people you put in prison and for how long. So ways to deal with it are diversion programs, right? Divert people out of the process entirely. ATI, alternative to incarceration programs, even though you don't divert them, and those are fundamentally different.
Yeah.
And the people who benefit only from ATI are stuck with a conviction and the collateral consequences, but at least they're not going to prison. And in the federal system, especially for drug offenders and other types of categorical types, there should be alternative to incarceration programs. There are, in a kind of a grassroots way. But then it's sentencing, and I want to, again, go back to something Hillary mentioned. You know, there are so many respects in which the commission I sit on is directed by Congress to make sure advancements in knowledge about human behavior that affect policy ought to affect policy. So yes, now the cognitive development of young offenders. Another one is trauma. Yet a third is, most of the federal sentences, believe it or not, the average fraud sentence is 24 months.
Yeah.
Most of them boil down to, should they go in or stay out? And here's a world of psychological study that's well developed, hasn't made it anywhere near the criminal justice radar screen. Attachment problems, insecure attachment. If you separate the parent from a child, it doesn't have to be an infant, a child, that can produce attachment issues on the part of the child that have lifelong adverse consequences. Does it mean that no judge should ever sentence, the old taste of prison? I think this person could use a taste of prison. It's a kind of a ridiculous thought. But does it mean that every parent who's on the cusp of a jail or no jail sentence ought never to get prison? No. But should judges know that one of the consequences of giving a person a taste of prison might be lifelong adverse psychological effects on young children in the home?
Right.
As I say, my wife's studying psychology, and all of this social science grows out of child services people removing children from the home inappropriately, produces insecure attachment, produces those problems. And she turned to me, knowing I'm on the commission. She says, well, you people ever think of this? Because taking the parent out of the home is just the other way. The other thing is another way of separating the child from the parent. My point is there is an insufficient degree to which things like the study of trauma, the study of cognitive development, insecure attachment, things we can learn from other disciplines, we're terrible at. Mm-hmm. It's only now, 10 years ago, there wasn't a single judge around that I knew who thought that someone could actually confess to a serious crime he or she didn't commit. We know that's kind of made its way partly onto the radar screen. But there's so many respects in which we're kind of siloed.
But can I ask, I just want to follow up though, because I really am curious, because you're the only one of us who sentenced people. I mean, for better or worse, I stick to this notion that sentencing is hard and it should be hard. It should weigh heavy, which is part of my objection to doing it's the same way that pretrial release should weigh heavy. It should not be done remotely because you should have to look someone in the eye. And I'm curious what you think would be the psychological effect of institutionalizing second look. Do you think that, because again, I don't know what that responsibility is like.
I respectfully disagree with the idea that a sentencing judge would actually kind of push off the responsibility to the second looker. I really do. It is so fundamentally human and so fundamentally heart-wrenching. I think the judges who want to lock them up and throw away the key are going to do that not because there's some second look person who's going to actually make the decision. Mm-hmm. It's just that's the way they are. But I'm not worried about second look producing less rigor and less conscientiousness on the part of the sentencing judge.
I thank you for answering that, because that really is my anxiety about it very much stems from that and the idea that anything that we do that makes the system bigger is bad.
Right. And I think that what's interesting is that what it actually does is it actually is providing opportunities for more rigor. And by that I mean that you were saying that it wasn't really something that was considered when you think about removing parents from the home, and that, that is in fact one of the scores under ACEs when a child has an incarcerated parent. But even in the second look realm, being able to explain the healing that will happen. So if a child has been separated from their parents and they're 6 years old and their parent then comes home, right, the chances of that child then not entering into the justice system has now just declined significantly, right? And so those opportunities that exist. The other thing that I would say is that, and there's some public defenders in the audience here, and they can correct me if I'm wrong, but when we started this work in 2018 to work on the first PIR law, we asked everybody, right? We asked advocates and abolitionists and public defenders, like, what am I getting wrong? Like, where are the unintended consequences? Because it feels like this could be an opportunity, but I've not practiced. I'm not a defense attorney. I don't know. And the questions that came up that was one of the questions, is an unintended consequence of this could be that prosecutors would then use this as a bargaining chip. And what I will say is that is not something, I mean, Quizon's here, you can correct me, but that is not something that we have seen happening. And we have a pilot here in California. We work with 9 different public defender offices in California. And when they talk about the issues around second look and what they want to see happening with prosecutor-initiated resentencing, I mean, I can report back that is not one of the things that they see. It was attempted, I heard once, in the very beginning, and the judge and the public defender shut it down. So thankfully, we're not seeing that, but I appreciate the question, and I think that every person that is advocating for any kind of reform or any kind of new initiative needs to always be asking this question and having these conversations about, like, what am I missing? Am I getting something wrong? And what are the unintended consequences? But I also think that one of the things that's really important to remember, and what I try to think about, is that anything that we're doing is kind of, I don't want to say experimental, but we are figuring it out as we go. And that's what an innovation is, and that's what doing something new and different is. And so it will not be perfect. And as you mentioned, that yes, it's not likely that the majority of people that are going to get relief under this are going to be people that have been in for 1, 2, or 3 years. But I think that for us, what's really important is that we're starting with the people who are in prison that we know have compelling stories that are not in dispute about whether they can come home. And then we need people like you to constantly be saying, but what about the people that have been there for 1, 2, and 3 years? And so to the extent that we can be doing this work side by side, because I think that what has happened in the past is that if we don't get it all the way right, or somebody on the advocacy side doesn't totally agree with our approach, then it's like there's like a breakdown and we can't be having a conversation, when in fact, we work with activists that are, they're on Twitter flaming the DA, and then at the same time they're working with us to present cases to the DA's office. And I think that is critical, that tension is critical, and that is something that I hope that we can see more of, because we need your voice, and we also need to recognize that, our work, we have a lane. We work specifically with prosecutors, we work specifically with people that have been in for a really long time, and we will do our best to get as many of them out as we can, and then work alongside of folks like you that are pushing on a different lever.
And I don't think it's impossible for the two things to
I
not
agree.
coexist on both the front and back end. In California, we passed SB 81, which requires that if a judge is going to add an enhancement to a sentence, they must look at basically ACEs. Has this person suffered childhood trauma? Has this person done this as a result of a drug addiction? A whole series, 9
And on the back
factors.
end, at resentencing, they have to look at that as well.
Well, exactly, that's what I'm saying, so coexisting, right? So
Right.
you can do both, right? In
Right.
charging and in sentencing. And then also, the second looks, let's say you get a bad judge who puts on the record, I don't care that you suffered childhood trauma, I don't care that you whatever, I'm gonna sentence you with these enhancements. Second look provides an opportunity to revisit, right? So you can kind of find a way to get around that.
Yeah, and I just want to flag, too, that what you pointed out is interesting, because, again, this is California. It's not where, for example, the bulk of my work lives. But what you've talked about there is guided discretion.
Yes.
So that's the other piece here, is that you're articulating sentencing standards that have independence and mandatory considerations built in, right? There are opportunities and instructions about what matters. And I would suggest that is missing from most sentencing in this country.
Does this have to be part of the system? In other words, if you're going to have a second look type of a system, or even a first act that allows for some of the second look, I mean, you're advantaging some people in the system, but you're also missing so many people who don't have the large law firm, who don't have the counsel. Is this a system that needs a lot more consideration, not only from the sentencing perspective, but from the perspective overall about how we're going to approach it?
You already
actually
know.
I'm sorry, but you reminded me of one thing I wanted to say that sort of ties into this, which is, particularly in the second look context, there's a lot of review of somebody's sentence or somebody's prison behavior. And I just want to point out that prison is not a great place for people to grow, right? You have to work extra hard. You have to work 3 to 5 to 10 times harder to do well in prison, well enough that somebody thinks that you're worthy of coming out. And particularly the younger you are when you go to prison, let's say you're 18, 19, 20, you're terrified. You're there for,
Right.
An act of impulse, and you're taken under the wing and used by other long-term inmates. It's going to take you years to be deserving. Or if we're talking about intimate partner violence, and you go to prison as someone who's been a victim of that and who's been victimized by someone else, and you're in an environment that is not conducive to healing, right? It's going to be really hard for you to look like an attractive candidate for resentencing. So I didn't want to lose that in all of our discussion about second look.
Yes.
And then, yes, we can go, let's move forward.
And, some advancements are seismic, some are really incremental. And just to kind of get down in the weeds, there are a couple of districts around the country where the chief judge has decided that federal defenders and panel attorneys cannot bring these second look motions.
Yeah, I know.
They won't be paid for them. In a perfect world, there'd be appointed counsel for collateral attacks. We don't live in a perfect world. There's a lot of injustice that happens day in and day out right under our noses, for which there really is no readily available remedy. I mean, it's unfortunate. So you can work at that seismic level, or you can kind of work incrementally and try to shame a chief judge into like, you're not going to let the federal defender take somebody who, were he sentenced today, his mandatory sentence would be 14 years. He's doing life without parole for a crime he committed when he was 19. And you have to wait until he's going to do a pro se? Like, there's little baby steps that can be taken along the way. And, a system no system is perfect, but all systems really need to be introspective and look at the little things that happen day in and day out. Those are the injustices, like mandatory minimums in federal drug sentences. They're easy to overlook because they happened every single day in every courtroom around the country. It doesn't alter the fact that if a judge would sentence someone to 2.5 years, but was forced to sentence that person to 10, like, that's wrong. That's not judging. That's prosecutors doing the judging. But we live in a world in which things like that happen so often, we grew calluses.
And Ellen, I want to just say, I don't think you want the perfect to be the enemy of the good. That's not where I want to be landing. What I'm trying to suggest is simply that, look, there's a lot of merit to thinking about independence, discretion, and sentencing, in part because that's where a lot of bipartisanship happens. It is much easier to create political consensus without the heat of the moment. It's much easier to create political consensus when you have these really compelling stories of some of these LWOPs, some of these young kids who are, from the Buried Alive program, right? People who were sentenced to life in prison without parole for nonviolent drug offenses. These are the stories that move people in much the way that the innocence movement did. The flip side is that when people fall in love with innocence and when people fall in love with the narratives of these excessive sentences, what tends sometimes to fall by the wayside are the day-to-day injustices that happen to hundreds of thousands of people who wind up sentenced only, and this is, I'll end while I started, who wind up with these time-served sentences, which is in large measure a way of saying, oops, you didn't need to be here. Oops, we didn't move your case through fast enough. Oops, there's not a single lawyer who's ever done any work on your case. It is being processed. This is some of what was talked about in the earlier panel about misdemeanors. And so all I'm really suggesting is that when we focus on discretion and independence in sentencing, that we pay attention to the fact that, one, everybody's independence and discretion is ultimately either unbounded or limited based on what a legislature does. And that's where we are right now because of this constant ratcheting up, right? That very rarely do you get elected by being soft on crime. Often you get recalled, right? I mean, it is not a popular position. It takes courage to be there. The second piece is that discretion ratchets both ways. And I promise you that the people who are on this panel and the people who are in this room are not the people whose discretion I'm worried about, right? I'm worried about the people who, we just had this happen in Texas, right? I'm worried about the people who are up in arms over another county's decision not to arrest people for first-time misdemeanor marijuana possession. I'm worried about the judges who are empowered to and eager to max people out because they can and that's how they're going to be reelected. And I'm worried about the places where, because the sentence isn't quite long enough, right, for us to get there, these wonderful storytelling mechanisms, these wonderful volunteer opportunities don't reach there. And so I guess I just get anxious that when the work that we're doing is good and we fall in love with it, I want to make sure that we don't forget that what we've fallen in love with is the very teeny tiny tip of the iceberg. And that if any of us walked into any state court anywhere in the country, particularly in any non-urban area, what we would see is rows and rows of people sitting with no lawyer, sitting with overworked lawyers, and whose cases are going to be sentenced because ultimately someone's going to look around and say, oh yeah, we got to deal with this one. And it's not going to be about how long they should be in jail, and it's not going to be about what services they're going to get. It's going to be because someone wanted to process their case. And that's the discretionary piece of sentencing we need to worry about.
Let me just say, we're almost ready for questions, so those who would like to ask questions, if you'd go to the mics at this point. But I just want to add that for all the law students out there or professors out there, and for those who are listening, there are many schools that have started programs similar to some of the programs at the large law firms and at other law firms, individuals, clemency projects, first step projects. And these projects are actually taking some of these cases, especially in areas that may be in ground zero, where you cannot have the public defenders actually handling the cases. But public defenders can teach the law students how to do the cases, and we've seen many wonderful projects that have come about as a result of this. So keep that in the back of your minds as you go out into the practice of law, that this is an area that you can be of assistance in. It's great pro bono work, and it's very rewarding, I can tell you that.
Can I just add to that, that just to double down on that, here in California, there's a prosecutor-initiated resentencing clinic that was started at UC Davis. It is partnering with prosecutors and the law school to identify cases and bring cases forward. If anybody is interested in how to start one of these in your community, Texas and other places, please let us know. We will give you anything and everything you need, the syllabus, the deck, whatever. We want to be able to see more of these clinics popping up. It is an amazing opportunity for students. Students have an opportunity to work on actual cases, and oftentimes before they graduate, they'll get an opportunity to meet the people coming home from prison. And I know that Stanford has a clinic. There's a clinic that's going to start here. So it is a great opportunity to address what you had said, which is there is we have some gaps here in terms of resources. There are far more people in prison that don't need to be there than we have resources to support them and get them home. And law students are a really great way to fill that gap.
I see we have some questions. So.
Just piggybacking on what Pam was saying about the quick processing of cases in rural counties, the same thing that's happening in Texas is happening here, where you have rural counties with, $300,000 spent on defense and $2.3 million spent on prosecution, and the defenders have, 800, 1,000 cases each. There might be like 10 prosecutors to those 2 defenders. I'm wondering, what is the role in California in this county-based system where all counties are deciding how much to spend on prosecutors and defense? What is the role of the ethical prosecutor to ensure that they have a fair fight on the other side, to make sure that when they're prosecuting, they're not just collecting all their resources for themselves and bludgeoning, the other under-resourced side on the other side?
So it seems unfair that you're calling on me instead of on Ellen.
No,
but
this is for everybody. This is like, Pam's idea, of course, but
No, it's
what
actually
should
not.
prosecutors do, right?
I will give you my 2 cents, which is that good prosecutors have to do the hard thing, and I'll say it, call bullshit when they see bullshit, right? But the problem is it's hard to know. Good prosecutors, and again, your office was filled with good prosecutors. Good prosecutors go and say, this lawyer isn't doing their job, and when they don't do their job, I can't do mine. But I don't know that that's always a prosecutor's job, and I don't know that that's always transparent. It's very, very difficult for a judge or a prosecutor to know whether a defense lawyer is doing their job properly, because the part of the job of a defense lawyer is to keep secrets. I will say that and I'm going to stop there, except for to say that there is a report coming out that my center is producing about workloads, public defender workloads in California. We'll be releasing that to the legislature. I want to say either the end of this calendar year or sometime in January, that Malia Brink from my office is writing. And so we're in touch with a lot of the prosecutors in rural California. We're aware of those discrepancies and the burdens that are being placed on those lawyers. But I will say this, I think very few people become prosecutors because they want to convict innocent people, right? Most people, I've known a couple, right? But by and large, people get up in the morning and become prosecutors because they want to do the right thing, right? No one's going out there to try and have an unfair fight. But I'm not sure that asking them to bear that burden is realistic, even if it's admirable.
Hi. So first of all, thank you guys for coming out and making this possible. I'm interested in gang enhancement and how they're being used in California. I know there's a lot of issues right now with disproportionately being used against minority groups. My question is, and it's for the whole panel, with gang affiliation and labeling an individual, whose sole responsibility or job should it be to make that call and make that and decide whether or not they're being gang affiliated? There is an affiliation. Just because I know that I've talked to professors before, and just from what I've seen, sorry, there can be several negative impacts, whether going through the criminal justice system or even outside in communities. It can be devastating for them if they're being labeled as a gang member or being affiliated with a gang. So who, in your guys' professional opinion, who should be the person making that call?
Well, we all bring our baggage with us.
Right,
And
right.
truth be told, I spent 10 years of my life investigating and prosecuting members of La Cosa Nostra, and thought there was a material difference between someone who happened to commit a crime and someone who committed a crime as his way of participating in an organization dedicated to committing crimes. It's actually the one respect in which I thought the federal guidelines, which were excessively punitive, kind of missed the boat. Didn't even have an enhancement for that. But your question is who decides it, because there are collateral effects to having been tagged as a member of a gang. So that count, and I'm going to get out of this mess in a minute because I don't know from California
Right.
enhancements, but it strikes me that there's a direct relationship between the stringency of procedural requirements and proof requirements on the one hand, and the effects of having been found to have been proved, whatever that requirement is, including gangs. So I don't know the lay of the land in California. It does strike me as not an unimportant factor, but it does strike me as an important factor to get right because of the effects, the longstanding effects it can have on a person.
Yeah. I mean, I guess just the answer to the question of do I think that the decision-making of bringing the enhancement forward rests with the prosecution, I believe that it does. I think that what I will say is that what I've seen from both being a prosecutor and working with prosecutors over the last several years is a warranted movement away from the expediency of tagging somebody as a gang member. And the evidence that is relied on or put forward by an investigator, that the shifts that have happened around that, and if I do think back to what was necessary to ascribe that somebody was in fact a gang member and warranted the enhancement to be found true, has become more robust to be able to make those kinds of determinations, and I think that that is warranted. And bringing the baggage and being in court and seeing sometimes how easy it was to find somebody guilty of that association. I came up in the era of the injunctions where you couldn't be on a street corner. So there has been movement, thankfully, to more science coming forward and more advocates pushing back. The other thing that I will say in terms of the work on the back end around enhancements and in what's happening in our prisons, right, is there has again been some movement around the use of validation to keep people incarcerated. And, when you have that gang validation associated with your case, it's almost a death sentence, right? It is almost impossible to get granted release from the parole board if you have that association. And what we have seen over the years, thankfully, is a movement away from validating people as quickly and readily, and also moving away from the requirement that people have to, quote, drop out, which means that they have to go lock themselves in a room with a correctional officer and then come out and everybody on the yard is wondering exactly what they said, right? Even if they went in there and said nothing. And the risks that that posed to that person, to the prison, to that person's family, and how people would not go into that room and participate in that and would instead have this sort of Hobson's choice between, well, if I drop out, I would be able to get granted parole potentially, but then if I drop out, I am going to put my family and myself at risk. So thankfully, we have seen, and again, this is really because of advocates that have been pushing for this at the prison level to move away from that. And we have now seen prosecutors that don't hinge themselves so much on are you validated, are you not, in terms of whether a person can be safely released, and are starting to understand what happens in the prison system and why people may even become associated with the gang for protection, or as Susan mentioned, that was just the person that they were associated when they got there. So we're seeing some movement there, but not enough. But I will say that we are seeing, I'm going to talk about progress a lot, but I just want to point towards the movements that we are seeing, and also because it's at the hands of advocates that are pushing these notions forward.
And it is, I think the definition of a criminal street gang is in the penal code, and it's something really ridiculous. It's a very low threshold, and I think that they're actually working on
Right.
Adjusting that definition so that it's a little more robust.
So I think our time is about up, and let me just say that there are... Oh, we are? Okay. Go ahead.
I'm a 2L here, and I spent the summer in the SF Federal Public Defender Office. And I was wondering if anyone could comment on, there's this practice where low-level drug crimes were being federalized. And so, normally would be taken care of by the city, and they have their whole processes. There's, San Francisco is a sanctuary city, and so there's all these kind of things that have been put in place to deal with the issues in the city. And, by federalizing it, there was like bypassing a lot of these things that the city has put in place, and so we would see, immediate deportation of all of our clients that had these very low-level drug crimes that the city would totally handle differently. And so I was just wondering about state versus federal police powers and any of the issues that are affected.
When I was chief of the criminal division in Brooklyn, if a case involved less than 2 tons of marijuana, we would send them packing because we had bigger fish to fry. In Knoxville, Tennessee, that case was front page in the federal system. So it's one illustration of it's a big country and there are lots of different arrangements between the feds and the locals. They don't always line up. They can't be reconciled around a particular theme. When we did retroactive lowering, when the commission did retroactive lowering of crack sentences, there was huge disproportionate geographical disparity. So in North Carolina, it seemed like there wasn't a single crack case ever handled by a local prosecutor. They all came federally, thousands and thousands. Whereas in a place like Brooklyn or Chicago or LA, it'd be a trickle. So it's not only local, but it also has to do with even personalities of the U.S. attorney as opposed to the DA and whether they're aligned in their policy preferences. So it's a great question, and there's not one single answer to it except that local dynamic between the Fed and the state.
Thank you guys for coming. I'm a student here at Berkeley as well, and I'm doing some work, Racial Injustice Act work with Chesa. And my question goes back to gang enhancements as well. I've been a victim of gang enhancements, grew up in San Diego, California. And for me, my question is, one, it's not illegal to be a gang member. The Constitution protects that, right? But they're also allowed to use the policy, gang dress, colors, association, which we are protected under the constitutional law to be able to do these things, yet they're able to incarcerate us at a disproportionate marginalized rate higher than anybody else. So I guess my question would be, because we know that that's unconstitutional, even though it's a state policy, how can we combat that? Or do you guys have any solutions regarding that? Because we know the prosecutor is always going to seek, right, the extensive when it comes to sentencing, and it's so easy to document a black and brown person because of the neighborhoods we grew up in. We love to wear colors. It's our culture. It's our high school. It's our football team. Yet we're still being prosecuted. And I know you say that there is some change in that, which is not really any kind of change because we have friends that are locked up for life behind gang enhancements. Even the Second Look Act they kind of like to leave gang documentation alone, and also being explained that it's derogatory in courtrooms, right, when you hear the word gang member. So that should also take place in the Racial Injustice Act. But I guess my question is, how do you see us combating a policy that is restricting our constitutional right? Because again, it's not illegal to be a gang member, it's illegal to commit crimes.
So I'm not from California, so I can't speak to that specifically. What I will say is that you're touching on the larger problem, which is who is making the laws that are empowering people to use gang status that way. And it goes back to the same problem, right? It's the acceleration of the impact of the over-policing and over-arresting of black and brown people, the processing, and here, again, I'm using that word very deliberately, the decision to process them through low-level cases rather than actually represent them and explore their cases, which leads to a criminal history that either ends up in something becoming a federal case or it goes and becomes a much more serious case. And what ends up happening, right, is there are these, I think it's kind of an exponential increase. And the only way out of that I see, and once again, I'm today's like poop in the punch bowl, but the only way out of it I see is electoral politics. Because I got to tell you that until you have an electorate that believes that that's unjust, right, no one is going to run on it, and no one is going to change it. And so what that means is doing exactly what the Second Look folks are doing, right, in the sense of telling stories and putting faces to it. You being able to stand up and say, this is who I am. I'm a law student at one of the top law schools in the country. Right? Let me talk to you about what this gang affiliation label means. And the more people understand it as a story and see you as a person, the more you will find, I think, and it's a long, slow process, that the idea begins to change. But the people who are most impacted are the people who have the least power because they're the least able to vote. So it's going to be storytelling to people who are not impacted.
I mean, and I would say, and we can talk after this, I would say that I'll tell you the same thing that somebody told me when I said I want to come and I want to change the system. I come from a community that saw a lot of things and experienced a lot of things, and I'm not going to be a prosecutor, that's for sure. I'm going to dismantle the system, I'm going to take it down. And I'm going to tell you what somebody told me was get involved in changing the system. Just get involved, right? So understand exactly how prosecutors think about the way they use these enhancements, the way the law works, and start to figure out how you want to see the law done differently. I'd encourage you to get involved, go to Sacramento, start talking to legislators, talk to Susan, talk to us, start talking about what you want to see, roll your sleeves up and try to get involved in seeing the changes that you want to see. That's what I would say to you.
Let me just make one point in the end. Being on the elder side of things, I started with the overcriminalization movement when it first started. And one of the things we saw in the overcriminalization movement that's very promising here for looking at discretion and looking at prosecutorial discretion, judicial discretion, and solving some of the infirmities in the system itself is that if you keep trying to educate people, it does make a difference. If you have hearings in Congress, it does make a difference. And if you finally get a Supreme Court Justice of the United States to actually use the word overcriminalization, it starts making a difference. So I want to leave everybody with some hope out there that prosecutorial independence, it seems very bleak when we look at it from the sentencing perspective right now, but there's a lot of people working on it. And it can make a difference, and it can make change. There are so many disparities in our system today. There are so many things that need to be corrected in our system today. But if everybody starts getting involved and thinking about it and educating others about it, it will make a difference. Let's thank our panelists today.